Okay, good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our June 21st, 2018 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the timely conversion of inter-multi-dwellings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the law and the Loft Board's rules. We'll first turn to our vote of the May 10th, 2018 minutes. Board members, are there any corrections or comments to these minutes? To this minute? Is there a motion then to accept the minute? Mr. Roche, is there a second? May 10th. Mr. Cobb. Ms. Rivera?
Mr. Carver?
Yes.
Mr. Bush?
Yes.
Mr. Hernandez?
Abstain.
Mr. Delaney?
Yes.
Ms. Torres? Abstain. Chairperson Thompson?
Yes.
Vote in favor, 2 absent, 2 abstain.
So that doesn't.
Give me a second. So, I got a legal question to ask. So, at that time, the board consisted of more or less.
We've had this issue before, where we had to wait for another meeting for lack of.
Is that going to be the same situation on the next meeting? Okay, just for formality then, we turn to the vote of the May 17th, 2018 minutes. Do we have a motion to accept? Are there first any questions or comments on the minutes? Do we have a motion then to accept? Mr. Hernandez? And second, Mr. Roche. Ms. Rivera?
Mr. Carver?
Yes.
Mr. Roche?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Ms. Torres? Abstain. Chairperson Thompson?
Yes.
5 in favor, 2 absent, 1 abstain.
So we did that one. Okay, great. Ms. Helene Balsam, Executive Director, will now give her report.
I just wanted to, in terms of staffing, welcome our summer interns, Trishon Raffington and Ben Winters. They were at the last meeting, but I welcome them again, because there's a few more people here from the public. We're also happy to welcome Terry Ryan, who's our new project manager, who's going to be operating our camera and doing other various miscellaneous things. In terms of the Loft Law, at the last meeting I had stated that the Assembly had passed amendments to the Loft Law. The City then issued a statement of support for the Assembly's bill, which I've distributed to all the board members to see, because you had expressed interest in that. After that period of time, the owners and the tenants started talking to each other, and there were intense negotiations, and we spent basically all of yesterday going back and forth with the mayor's office, talking about drafts of several different documents. We were on the phone with various people, including Assembly member staffers. Unfortunately, the legislature did not get to the Loft Law, so for now it stays as is. Registration, so we sent out the registration invoices on June 6th. So far we've had 63 buildings register, and we've collected $179,000 in registration fees. In In addition to that, the revenue for May, the unofficial revenue for May was $14,233.75. That's foil. That's where the 75 cents comes from. In terms of enforcement, the HPD inspector assigned to the Loft Board conducted an inspection of an IMD building at the direction of the Housing Court. That inspection yielded violations for no elevator, no running water, no intercom, and no gas. Staff is continuing to work on an enforcement plan and hopes to have it finished by the end of the month. In the litigation department, the board had filed a notice of claim against an owner who began a bankruptcy proceeding. After we filed the notice of claim, the owner made a motion in bankruptcy court to sell the property free and clear of any claims and encumbrances. We asked the bankruptcy division of the law department to file opposition papers explaining the duty to legalize IMDs under the Loft law and that the property couldn't and should not be sold free and clear of any claims and encumbrances. After the law department filed their papers, the judge requested the Loft Board to prepare a letter brief to the court explaining the nature of the tenant's rights under the Loft law, and we did that. The owner maintains that the tenants are just holdovers and that they have no rights. So we hope that the bankruptcy court will rule in our favor and keep the tenants' rights in place. And the other litigation that came in was that the owner of 58 Grand Street filed another mandamus proceeding asking the court to order the Loft Board to decide the tenant's request for consideration. There's actually a court date today. I have not heard back yet as to what happened, but that's it.
Thank you. Any questions from Ms. Wilson? Mr. Lane?
The HPD inspector that inspected the IMD building at the request of Housing Court. Can I have the address?
79 Lorimer.
79 Lorimer. And the case that's in bankruptcy court,
Oh,
533 Greenwich. Can I get a copy of the papers of that?
bankruptcy?
Yeah.
Yeah, sure.
Okay.
Any other questions for Ms. Wilson on the report? Comments? Okay, so we now turn to a vote on this month's cases. We start with the appeal and reconsideration calendar. There's one case on the calendar. It is Bran Catherine Blessing at 870 Broadway, Manhattan. Docket number R0364, and I'm pleased to have our new law student intern, Mr. Winters, present the case. Yes.
On February 27, 2018, the board issued Loft Board number 4738, which granted Article 7C coverage to the building, but denied Brianne Catherine Blessing's claims for protected occupancy and rent overcharge. On March 29, 2018, the tenant filed an application requesting that the board reconsider its decision. On April 10, 2018, the Tenants Council withdrew her reconsideration application with prejudice, and the proposed order before you accept this withdrawal.
Thank you, Mr. Winter. Does anyone have any questions or comments on this case? Then do we have a motion to accept this case? Mr. Carver. The second, Mr. Roche. Mr. Rivera.
Mr. Carver?
Yes.
Mr. Roche?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Abstain.
Ms. Torres?
Yes.
Chairperson Hudson?
Yes.
5 in favor, 1 abstain, 2 absent.
Thank you, Mr. Rivera. There are 6 cases on our summer calendar. They're voted on as a group. And I will read the cases off individually who they are. They're Benjamin Smith and Sonia Hiling at 1099 Flushing Avenue, Brooklyn. Docket number P00058. We have Campbell Watson at 57 Thames Street in Brooklyn. Docket number TA0244. Then there is Charlotte Fall and Daniel Schneider, Mary Beth McKenzie, and Tony Masak at 517 through 525 West 45th Street in Manhattan, docket number TH0211. The next calendar is again Charlotte Fall, Daniel Schneider, Mary Beth McKenzie, and Tony Masak. Same address at 517 through 525 West 45th Street in Manhattan, and that docket number is TM0094. Next case is Patricia Soetti and Eric Weinberg at 44 Ward Street in Manhattan. That docket number is TR1287. And then Jessica Mays, Risa Harris Gerstein, Lauren McCullough, and Melissa Kelly at 44 West Street, Water Street in Manhattan. And that docket number is TR1296. Does anyone have any comments or questions about this case? Mr.
I have a comment about case number 3 at 57 Thames Street in Brooklyn. I'm concerned at the report that I got at the private meeting at my request with regard to the fact that this building doesn't seem to be making any progress under the Loft law. I was told that it hasn't filed for an alteration application, obviously doesn't have a permit. We objected to a letter of no objection, and the owner doesn't appear to have an architect. I have, at the last 2 board meetings, expressed concern about 86 East 10th Street as being a building that I think, as being an IMD building, that I think the Loft board should ask itself how it can achieve its mandate. And that statement that you read at the start of every meeting, Mr. Chairman, these are essentially people who are kind of giving us a gesture of lack of interest, for want of a better word. And I would certainly add this building to them. I'm concerned about these. And I know that I recall that at the recent meeting that the executive director stated she would have some plan, I think it would be fair to call it, to share with us no later than the July meeting. And I look forward to that, and I would ask that that plan address a building such as this as well. Yeah, I mean, and actually I'll go a bit further. I was asked in conjunction with the discussions in Albany, to try to provide some statistics about what's going on with the Loft board, and which I did, stating that these were things that I had culled from the records. It's not official Loft board staff. If you want to know what the board staff thinks, you got to talk to them. But I'm finding that in the way we currently provide information to the board members, it's hard to spot the bad actors. And in particular, some months ago, I provided both Ronaldo and Helene with a copy of a breakdown that used to be provided under the previous executive director that would detail all the buildings in the system under 281.1, all the buildings in the system under 281.5, with the number at each milestone, which was extremely helpful. And that report no longer comes out. What I was able to determine, including steps going through the minutes of the last 8 years and counting the number of LE cases, is we're actually moving buildings out at a pretty good clip. In fact, this year we could have a record year. We've moved 11 out already just through the May meeting. We don't have any on this docket. Helene did share information with me that shows a considerable number of the old buildings, of which there are about 200 left in our system, are at or near the exit point, either having a C of O, a temporary C of O, or I forget the term you have.
Removal pending?
Removal pending. So of the 200 old 281 buildings, there are about 100 that are clustered there. So that means out of the 900 or so IMD numbers that were issued prior to the 2010 law, really there are about 100 of those that are somewhere fumbling around on the track, but nowhere near the finish line. And there appear to be about, at this point, 125 buildings covered under 281.5. There, so far, the progress is not, there aren't that many at the finish line, and frankly, I wasn't able to sort through the raw stats. But I'll be happy to provide you a copy of that summary to which I refer again.
Well, I have...
And just to finish my point, we need a plan for the people who don't want to get with the program.
So we are still working on the plan, and we hope to have it finished by the end of the month, as I just said in my report. In terms of data, I have a spreadsheet. It has all of the active buildings on it. It can be sorted in any one of many different ways to come up with the figures that you need. I think it's much more flexible. I will say that I constructed it based on data that I had and personally tried to verify as much as I can, but there are boxes that are missing. You know, you talk about the number of 281.1 buildings, or 281.4 buildings, or 281.5 buildings. There are buildings for which I cannot figure that out. And I'm talking like I pulled the registration folder for each building to try and figure it out, could not figure it out. So, you know, I believe in trying to have very accurate data, and I don't want to give inaccurate data. And I feel very badly if I make a mistake. So, you know, I think that what I'm providing is so much more flexible than what you used to get. You used to get a piece of paper. Here you're getting a spreadsheet that you can sort in any way that you want. You want to know how many 280, you know, you want to know where people are in the milestones, you can sort it by milestone. You want to know how long it's taken them to get there, we have the date that they achieved the milestone and today's date. That'll tell you. So I'm not sure why having a paper report would be better.
I can give you a couple of thoughts there, but I certainly agree that the record keeping by the board, both of the status of loft buildings, on the status of code compliance, and also some of our historical records, all the early hearings for which there were transcripts made, those all got thrown out 15 years or so ago. So I acknowledge that you inherited a problem. However, I don't think it's realistic, given human nature, to expect, hey, board members, here's an Excel spreadsheet, which I requested of you, spend time sorting it out. A one-page snapshot is actually a very handy thing to provide, in my opinion. Maybe I'm just old school.
Or maybe a demonstration. You're saying the end of the month we'll have that spreadsheet?
No, the plan doesn't have the spreadsheet. The spreadsheet is just keeping track of the buildings, the active buildings, and where they are in the process and how long they have been there. And it's taken me months to put all of that data together. And I'm talking cross-referencing documents, biz, all kinds of things. Monthly reports, the Loft board database, I mean, multiple
And
lookups to come up in the spreadsheet.
Sounds great. We're going to have access to it?
I can send it to you. I'm more than happy to send it to you if you'd like to see it. Sure. I mean, I have it for internal record-keeping purposes, because the lady asked for it again. But I'll be happy to send it to you.
Yeah, that sounds great. Maybe even a lesson on how to sort
Lesson on how to sort.
through it so that you can, you know, so that we can figure out how best to sort to understand
Sure.
status.
Sure.
Okay, so Ms. Paulson, I guess as far as the enforcement plan that you're concerned with, I think Ms. Paulson was saying by the end of the month, certainly by the board meeting, you should be able to provide that to the board, and the spreadsheet's all available. Did we answer Mr. Tomato's question about whether or not we're going to give him the paper report or the spreadsheet, or are we seeing it?
Let me try to drill down on this just a little bit. One of the things that one document that I examined recently went out of its way. It was a draft proposal that a small group of owners or group of owners of some size was circulating in the legislature, sought to rewrite Section 280 of the Multiple Dwelling Law, the legislative findings, and the basic thrust of what they wrote was that the loft law has been a huge failure, and that the very few buildings have been legalized, and that kind of sent me off on a quest to figure out what the case really was. And what I discovered is actually the loft law has been pretty successful, even with some of the problems that it had to confront after the 2010 expansion and the amendments and dealing with bigger buildings. And in fact, with 300 buildings left, having seen about 1,200 registered, that means 900 or so have moved through, have gone on, a large number of them into rent stabilization. A few co-ops, a few buildings that reverted to commercial or got demolished, but for the most part have succeeded and exited the program. When you've got people with conflicting viewpoints in a place like Albany saying it's good, it's bad, we don't know, the answer is not, here's a spreadsheet, you figure it out. They don't even know what the legalization compliance steps are. So having one page that's as simple and clear as this, which is the most recent document I could find from July of 2014, buildings for 281.1, 281.5, total, where they all are, incredibly helpful. And by not doing it, what you're really doing is not telling your own good news story.
Are you saying that we should have that at every board meeting or something to put up?
Quarterly, once a year. I haven't seen one of these since, the most recent one I could find in my files was 2014. I think there may have been a couple subsequent to that. But neat, clean, you want to know what's going on. Gee, why are there still 300 buildings? There were 300 buildings 8 years ago. Well, but also 100 plus moved out and 100 new ones came in. Try explaining that to people who have like 2 minutes of time.
But you're not going to see that on that one page. You're not going to see that 100 moved out and 100 moved in. That page isn't going to show that.
That's true. However, if one had one of these for every year, you could put the story together a lot more readily than plowing through minutes online.
Is it it's a staff issue?
Okay, we'll consider, we'll work it through and see what can be done. Certainly, I'm all for good, telling this good stories and good news that the work that the staff does.
I'll be happy to send you a copy of my analysis if you would like.
Yes.
Sure.
Chuck, can I do one back?
Well, I'll send it to Helene,
Okay.
I'll distribute it.
Yeah,
and she'll distribute it.
thank you.
That was
Sorry.
three.
Okay, that was number 3. Are there any other comments on these cases? We have to move to a vote. So that with no other questions, then we'll move to a motion to accept these cases. Is there a motion?
As a group, correct?
As a group. Mr. Robinson is, Mr. Fernandez is the motion. Any second? Mr. Carver? And then Ms. Rivera, could you please?
Mr. Carver?
Yes.
Mr. Bruce?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 2 absent.
Thank you, Ms. Rivera. All right, so the master calendar, there's one case on the master calendar. It is Fiona Campbell Stone, Peter Alexa, Bernard Walker, Vlad Tishper, Jason Beckford, Stephen A. Westbrook, William Foster, Nico Hout, and Eric McAndres. The address is 1315 Ames Street in Brooklyn, and the docket number is TR0889. Miss Level, she will present this case.
Board members, on April 21st, 2011, 9 occupants of Unit 1W in the building located at 13 Thames Street filed an application seeking protected occupant status. In the stipulation dated February 1st, 2013, the then owner agreed that 7 of the 9 applicants were protected occupants. In Loft Board Order Number 4225, dated January 16, 2014, the Loft Board, among other things, rejected the stipulation and remanded that the protected occupant application be remanded back to oath. The Loft Board also dismissed, without prejudice, the protected occupant claims of 2 of the applicants. In Loft Board Order Number 4522, dated May 19, 2016, the Loft Board determined that 3 of the 7 applicants were protected occupants, but denied the claims of the remaining 4 applicants, which included Fiona Campbell Stone and Stephen A. Westbrook. On September 27, 2016, applicants Stone and Westbrook filed an Article 78 petition challenging portions of order numbers 4225 and 4522, which rejected the stipulation. The court granted the Article 78 petition and held that the Loft Board erred when it rejected the stipulation on the basis that 7 unrelated people violated the maximum occupants under the MDL Section 4, Subsection 5, without determining whether the occupants lived together and maintained a common household. The proposed order before you accepts the stipulation and finds that there are 7 protected occupants in Unit 1W.
Thank you, Mr. LaBelle. Does anyone have any comments on this case? Do we have a motion then to accept this case? Story? Mr. Delaney? Is there a second? Mr. Roche. All right, do we have Ms. Rivera?
Mr. Crawford.
Yes.
Mr. Roach.
Yes.
Mr. Hernandez.
Yes.
Mr. Delaney.
Yes.
Ms. Torres.
Yes.
Chairperson Hudson.
Yes.
6 in favor, 2 absent.
Thank you, Mr. Rivera. All right, so we now turn to the much anticipated piece of the meeting, which is the returning to our discussion on the rules on Chapter 2. From here, Ms. Dawson will take the charge.
So we had ended the last meeting with a discussion of a proposal by Mr. Delaney to change 2-08K to provide for to insert the words "in legal operation" into the rule. And we had an extensive discussion about why it might or might not matter. And the fact is that if something is in illegal operation, should that trump some residential applicant getting IMD status? That's really sort of what it came down to. We were asked by the board to see whether or not we could come up with a definition, and we spent quite a bit of time trying to figure out what in legal operation would mean. And there are a lot of possibilities, but given the fact that the law yesterday didn't pass, we are thinking that perhaps our time is better spent on issues that we can actually deal with, since this rule would only apply prospectively and we can still no longer take coverage applications. So for the time being, we would prefer to put this aside and move on to other things.
Yes, I said that we're going to come back to that, right?
We
We
can come back to
can
it
come
at a
back,
later
this
date,
is just so
but
that we can deal with the things that are more important right now.
Could you just expand on your thinking with regard to that kind of change being prospective?
so rules are usually passed prospectively and they apply to new cases, they don't apply to old cases, they don't look back in time.
And the dividing line between a new case and an old case would be application date?
It would be applications filed after the date the new rule goes into effect. On or after the date the rule goes into effect. So if we change the rules and they go into effect on, I don't know, July 1st, then anything filed after July 1st goes under the new rule, on or after July 1st goes under the new rules, anything before that is processed through the old rules.
So therefore, in your view, were the board to decide to include that language, that would not apply to any case that's currently, say, in discussion at oath?
Correct.
I wonder, Elaine, if we could get some legal research on that proposition. I certainly hope it's true. And when I say true, I hope you're fine about it. And I say that because one of the rules somewhere in our existing rules says that it will be effective as of the date. Somewhere in our rules, they make a point of saying what the date it will become effective. So I'm concerned that your proposition isn't accurate, that a rule change would apply to a pending case.
Oh. No, I mean,
No?
you could have a rule that you're enacting that becomes effective further on down the line, but I've
think
never
that's
seen
what
a
I'm
rule that
thinking of?
reaches back in time.
Okay.
The applicability of the rule doesn't go back in time, but effective date of the rule can be further date, or it could be right away.
Normally you publish the final rule and it's effective
90 days.
35 days after that, unless the mayor signs a statement of need or something like that. But you could theoretically enact a rule that says this rule is going to take effect in a year. For example, there was a whole bunch of DEP stuff that came out about changing fuel in boilers. So, people had until a certain time, they enacted a rule that said you're going to have until this date to change to numbers, from number 6 to number 4, and then from...
Meaning the body of the rule.
In the body of the rule itself, yeah, and then from number 4 to number 2 or something like that. So that was one rule that was prospective in terms of when people had to comply. So,
Well, I'm just thinking of, one of your proposals is to change the standard of proof or change the burden of proof.
right.
So that would not apply to a pending case?
No,
It would not.
no. Or at least if it would, nobody's told me. I
Okay.
contemplated that, but we can have somebody undertake the research.
Okay, thanks.
Can I ask a question too about that?
Yep.
Elaine, last meeting, I think part of that burden of proof was because you said a lot of cases were stuck in dealing with that issue. So you're saying even if we wrote the rule, it wouldn't help?
It would not help
alleviate.
pending cases, that's correct.
So when you mentioned that, you were just thinking for the future, it would...
That was the impetus for proposing the rule to begin with. Okay, was that, it's interesting, like, the law is passed and you have a vision of how you think things are going to work, but in the end, it doesn't necessarily play out that way, which is why you can revisit rules. So here, I think, was an example of a rule that didn't play out the way that perhaps the drafters of the rule thought it would, And we were asked to take a look at it and say, well, could we change it? But it's not going to look back in time. And there are all kinds of reasons for that, including the fact that people have made decisions and perhaps there are property interests that are affected based on what the rules were at the time. So,
The law could, all right?
well, the legislature can, like the Loft law was a remedial law, right? So the legislature can enact a law that looks back, which they have done here. But as far as I know, we don't have the authority to do it.
So Helene is going to,
We'll do the legal research on the effective dates, and then we will, and I would like to table this discussion until we cave for now, and move on to other things. That's okay.
I'm okay with that. Is it, board members okay with that? It's just temporary until we get to other things that we need to know. Thank you, go ahead.
Okay, so then Mr. Farmer.
Excuse me, before we go forward, in the private meeting, I had asked that certain discussions that we held about how we're going to take up things in what order be recapped in the public meeting.
Correct.
Right, so my plan for this meeting was to talk about 208K, and then Mr. Carver's proposal for 29 RCNY 2-01, which we had talked about last time, and he said he would send something, and he did, and then hopefully move on to 2-09B, which is the protected occupancy rule. So that was the order I had contemplated for this meeting, which would bring us to 29 RCNY 2-01, Mr. Carver's proposal.
So it's a 4-page proposal, and much of it is cleanup, but the substance of the proposal is on page 3 at the bottom. And you'll see towards the bottom there are 2 lines that have a strike through. And the sentence that I'm proposing that we strike is that the applications for extensions of the deadlines will be limited to 1. And with the substance of my change being so short, it's really merely striking. I wanted to just spend some time and give you some background as to why I think we should strike this. So the legalization milestones in the Loft law are quite short. So short that many, if not most of the owners can't meet them. And the legal consequence for missing the deadline is that the tenant's obligation to pay rent becomes unenforceable, meaning the tenant need not pay rent if he or she does not want to. Human behavior being what it is, if you don't have to pay for something, you might not pay for it. And the failure to pay rent leads to a lack of income on the owner's part to pay for the work required to legalize. And then we have buildings that languish in our, here at the Loftwood for years, if not decades. Some even go bankrupt in the meantime. Now, the law itself permits the board to grant extensions, but only if the owner meets a test that has 2 prongs. One is that the extension must be needed for reasons beyond the owner's control. The second being that the owner must demonstrate good faith efforts to satisfy the milestone. And I'm not in any way proposing that we alter this standard, nor can we. Now, the Loft law contains no limit on the number of extensions that can be granted to an owner who meets this test. Yet our current rule imposes a limit of just 1 extension per milestone. Now, there are lots of reasons beyond the owner's control for why an owner might not be able to meet one of the deadlines. And the reasons are often independent of each other. So our current limit of just 1 extension is just not reasonable in that it prohibits an owner who is making efforts in good faith from being able to collect rent if he runs into more than one obstacle, because he only has the opportunity for one extension. And the current rule, in essence, gives the tenants a reason to make the process longer than it need be, because if they don't want to pay rent, this is one way not to. So my proposal is to eliminate the number of, the cap of one extension and have no limit. It's consistent, and of course the owner would still need to meet the statutory standard of reasons beyond the owner's control and operating in good faith. So the proposal is consistent with the law, which does not have any limits, and I think it's in the public interest because it will turn on the rent flow, which is the money needed to legalize. Much of the many of the problems that the owners experience in legalizing really boil down to this one sentence in the rule, because this is what cuts off the rent. And a tenant who wants, so it really incentivizes a tenant who does not want to see legalization to delay. And that's obviously not the purpose of the law that we're implementing. We want to foster legalization work, and the best way to do it is to keep the rent flowing. To keep the rent flowing for those owners who are meeting the standard would be to strike out this limit of just one extension, which is in no way required or even contemplated under the statute. There are lots of other things going on in the proposal. They're largely drafting cleanup issues. There's one other issue of substance. It's quite minor. It's on page 1. There's a 90-day time frame that I'm asking that we increase to 120 days. This is the time period that the owners would need to marshal to show their good faith efforts, increasing that to 120 from 90. The reason being, I'm told, especially when dealing with architects, when you've got fine art architects, you got to speak to them, you got to get contracts with them, and 90 days has been, based on experience, a little on the short side to really properly be able to show good faith. So I'm asking also to extend that 90-day period just a little bit. That shouldn't be controversial. But the substance of the change is really to strike the limit of one extension per milestone.
And you're asking for limited?
As long as the statutory standard is met, and that's because things happen in the future that are independent of what has already happened. So when you encounter another problem beyond your control, and you've been acting in good faith, yes, you should be able to get an extension every time you encounter something beyond your control that inhibits your ability to meet what is undeniably a very short time period.
Do you see instances where that could be abused and limited?
No, because this is going to be controlled by the board. In other words, the application has to be made by the board, and the owner has
Staff.
yeah. Well, when I say board, I mean staff. Yeah. The owner has to demonstrate reasons every time.
So do you have a sense, Mr. Carver, of the magnitude of the problem that you talked about with the owners are facing regarding holding the rent, like in terms of numbers?
I've actually asked one of the law firms to do a survey of some of the firms that handle the bulk of the cases to see what that number is. But my impression is that it's going to be more than half.
Of the buildings that are active?
I'm not sure if it's the half of the buildings or half of the units that are not in compliance. So, but I'm gonna. That's in progress. In terms of buildings that are not in compliance, that's probably a number that can be derived from the spreadsheet that we were talking about, and I assume it's a very large number.
Go ahead.
Wait, you're assuming that half the building's tenants are paying rent? Is that what you're saying?
No, I'm saying that amongst the units amongst the buildings that are not in code compliance, my impression, and I don't yet have the survey result, but my impression is that more than half of the units that are not, in which the ability to collect rent is unenforceable, are not paying rent.
Or in reverse, is that the landlords that are not providing water, gas, basic services to their tenants, are those possibly the ones where they're not paying rent?
I'm just talking about when code compliance is the legal basis. But let's talk about data for a second. You know, legislative drafting and rulemaking is not always done in response to exact hard data. It's based on human behavior. It's based on general notions of how people behave. And if you're out of compliance with the deadline and you don't have to pay rent, we know that people might not pay rent. So the fact that I don't have a hard number for you at this moment doesn't change the fact that if someone doesn't have to pay rent, they might not. And legislation and rules do respond to this possibility, notwithstanding that I don't have a hard number for you at this very moment.
I would have to say that I think you've constructed what I would view as a straw tenant, and I don't think it's a very effective way to press your argument. Tenants may be on rent strike, they might go on rent strike, maybe half of them are. I don't think those numbers are correct. I'd certainly be happy to look at any hard data that anyone could generate. But more to the point, why don't you give us some examples of what the issues are that require extensions? You're saying we need more extensions because the tenants aren't paying rent or they might not pay rent. There's also a statistical chance that all the molecules of air moving around randomly in this room could all gather in one corner and we'd all suffocate, but it's pretty slim. So I'd rather hear about what problems the owners are actually having rather than put this on the tenants.
Chuck, I did say the word obstacles, and I have 4 pages worth of obstacles that I will read to you shortly. The issue of non-payment of rent is a potential consequence. That's a legal fact, and I will talk about those obstacles for you. But let me just.
Well, I just wanted to kind of sort of chime in defense. If we roll back the clock a few months, I know I, for one, and I can't remember who the other players are, had actually requested that we get some people in here to give us some of these obstacles. We bring in some professionals from the industry, both from a tenant's perspective and from an owner's perspective, to present to the board what are some of these obstacles. So I don't exactly know what happened to that.
Mr. Roche, that was regarding sale of rights, that wasn't regarding this issue. It was about experts to talk to us about the effects of sale of rights.
Okay.
I mean, whether or not they would have converted into those things, we don't know.
Well, you're right. With all due respect, we don't know, okay? But it's also something that we never followed through with, and
Because that was
You
never
know,
known.
now now we want to get hard data, and certainly we all deserve hard data, but, it's like, this is not the first time we've done this dance with trying to get some of this hard data, and, so, I still think it's a good idea. I think there were other people, at least at the time, that thought it was a good idea.
Are you talking about getting the experts in, the idea?
Correct. You recall this conversation, right, Joe?
Yeah,
And it was impartial. It wasn't that we were only going to have people come in and speak on the problems that the owners run into. We were going to have people come in and speak on the problems that the tenants run into.
James Paul?
I just want to address that. I'm very leery of having that happen. I don't think it's necessary. I think it's fine to have a list of things that owners are saying that they're facing. Basically because what could happen is that whoever comes in to speak will digress into talking about pending cases, and that would be very bad, because then there would be nobody to vote on the cases, and you would all have knowledge that you're not supposed to have, that's outside the record. So I'm not necessarily, while I understand where you're coming from, and it would be great to have everybody tell stories, maybe we could just get people whose cases are done in that situation.
Or we could come up with another mechanism to get some of this hard data that I know some of my colleagues here have alluded to in the past, myself included, that we seem to, for lack of a more professional term, just seem to keep kicking this issue down the road of getting this hard data. Not for any real particular reason, but it's a little difficult to contact a law firm that represents tenants or a law firm that represents owners, or anybody else for that matter, and say, oh, by the way, can you take some of your billable hours and do us a favor and throw some hard data together? And then what's going to happen is, we're going to have the hard data here, but we're not going to have anybody to question as to how the hard data was arrived at. So it's just going to keep drawing out.
So, can staff tell us a little anecdotally about the problems, or is this something that staff would find a lot more helpful in terms of their making determinations? Do you find that in some cases that come before you that you prefer or need to be in a position to make an extension, you're prohibited from doing so?
Yes, that's definitely true.
Does it happen a lot?
It happens enough that it bothers me. Really what we're talking about here is people that are doing what they're supposed to do. We're talking about owners that are doing what they're supposed to do. And the problem is that it kind of gets confused because there are a lot of owners that aren't doing what they're supposed to do. And my understanding is that certainly at one point in time, there were a lot of abuses of the extension process. So I think, I understand that this was a backlash from that, but if you have owners that are really trying and tenants that are willing to work with them, I don't see a harm in granting an extension. Rent aside. I understand that that's underlying it, but somebody who's doing what they're supposed to do should have an opportunity to continue to do what they're supposed to do. That's sort of how I feel about it.
Mr. Carver, could you, I don't want to take from anybody's questions, I'll just, Mr. Carver, can you kind of go through some of your examples that you talked about in terms of, I want to hear talk about reasons that are beyond owner's control.
Yeah, everything on my list is just that.
Okay.
And the statute itself lists some of them. One is you have to get some sort of landmark approval.
What?
Landmark approval.
Oh, landmarks.
If the building is landmarked. You need to obtain a variance from the DSA.
Oh, you said landlord approval.
Landmark. need to obtain a variance from BSA if you're denied reasonable access to a residential unit by a tenant. If an architect takes too long to prepare something or to do anything, even if they know there's a deadline, and even if they're paid well to do it, if a health issue of an architect gets in the way. I'm told that one of the architects who does a lot of work here at the Loft Board, both for tenants and owners, had to go for surgery, and his absence resulted in delays of something like 20 buildings. If you need to appeal a determination made by the buildings department or the BSA, if you have financial hardship, if the owner has financial hardship, it needs time to apply for a loan. Elevator legalization issues, legalizing a freight elevator apparently is very onerous and costly. There aren't that many contractors who do it. Commercial tenants can be an obstacle. If the owner needs to get access to one of those units and the commercial tenant doesn't cooperate, the owner has to go to court to get access. If there's litigation over coverage, that takes years, as we've seen.
Well, litigation over coverage, I mean, if the unit is recently covered, they can get an extension. We have that in the rule already, right? If for recently covered units, they can get an extension, they can apply for an extension.
But isn't the deadline from the claim of coverage? Right?
Yeah,
Deadline is from the claim of coverage.
yes,
And that litigation can take years,
yeah.
well beyond the deadline in the statute. So, any number of
No, but they would get an extension though. They would get, so let's say somebody filed a case in 2015 and we granted coverage in 2018. They would file within 90 days to get an extension, and we would, assuming that they demonstrated good faith efforts, right, which depends on a newly covered unit, we would give them an extension past that. So the code compliance deadline looks back, but the extension would go from the date of the application that was filed for the extension.
is that the one that's counted as one and that's it? Or
Yeah, that's the one.
so that's the
That's
problem?
A1.
All right, so that's the problem. So then you have a problem with the elevator, and you need to get your appeal from the BSA. So all these obstacles are independent of each other, and if you've used up your one, you're out of luck. So that's the answer to your question about obstacles.
So again, I want to ask, I mean, is good faith, would good faith mean that you contemplate some of these other issues ahead of time? You know, I mean, you don't want to solve one issue here and not, I don't think it would be good faith going forward if you don't anticipate the fact that there is going to be a problem legalizing your elevator. And so when that time comes, you say, well, I need more time now, I need an extension because my elevator needs to be, as an example, it needs to be legal.
Okay, so that phrase, good faith, is vague intentionally, I imagine, to account for possibilities that we might not think of right now. But if you think that if you think that the regs should have examples of good faith, that's something we could work on.
Mr. Chairman, I think I sort of understand you to say that you are leaning towards preferring the 90 days, but granting the executive director the leeway to grant extensions based on circumstances.
Well, not me, the board, I guess.
Well, but, okay, but I kind of like what you said, so I just wanted to kind of frame it to make sure I was understanding.
Can I just say how it works now, just so you'll know? I mean, an owner files the request, it is served on the tenants and other affected parties. Everybody has a right to answer, so after the answer period, it it goes to the executive director, I examine the record. I will also look at Loft board records. If it's a new owner or a newly covered unit, I'll look at the 90 days. And then I will make an administrative determination based on that. And good faith is going to vary from case to case, depending on the complexity of the building and what's being done, et cetera. So, that it's due to circumstances beyond their control, usually that's not, for new owners, obviously, clearly they're taking over after the deadlines have passed, so they don't have to demonstrate circumstances beyond their control. For the newly covered units, that could be an issue. So that's basically how it works. And it goes out in letter form as an administrative determination, and it's a bit appealable to the board, and you have seen some of them, and you'll be seeing more in the future. And that's how it works now, if that helps people in terms of how it's done. So we're doing basically a case-by-case analysis now. So.
Okay. Someone else?
My question was going to be along the same lines. Are you getting lots of requests for extensions?
We have a handful, I would say 12 to 15. I mean, I think certainly if we change the rule, we'll get a lot more, right? I mean, somebody who's already gotten one isn't going to apply for another because the rule says they can't have another, even if they're meeting the statutory standards. So why would they bother to apply? My guess is we will get a lot more if we change the rule.
Well, drawing on Mr. Carver's theory of human nature that tenants who don't have to pay rent may not pay rent.
I don't know if that's true.
I don't know if it's true either. I think it's baloney. But similarly, I would think you'd get a number of owners who didn't know thoroughly that they couldn't get a second extension, at least trying to get a second extension.
I mean, we've had people file for second extensions, and I've decided it on that basis that you can't get a second extension. I think we actually have a court case pending on that issue.
And would you say you've gotten 5 of those in the past year, 50 of those in the past year?
I don't know if it's even 5.
And when you said 12 to 15 extensions, is that currently pending or per month?
No, I don't know what's currently pending. I think we're pretty up to date. There may be 1 or 2 that have come in that are still in the answer period, or the answer period just finished. But as far as I know, I think I'm pretty up to date. Yeah.
So it's not like we got 1,000 cars trying to go through the tunnel and there's only 2 lanes.
No.
We're not swimming in extension requests.
No.
And your proposal doesn't add to the grounds for seeking an extension. And it doesn't change the standard, but it doesn't seem like there's a problem here.
No, everyone's already used their one.
Right.
So
That's the problem.
That isn't just what you're
You
saying.
haven't proven
Everyone
anything.
is-
How many is everybody has already used their one?
No, I think in different, let me just, Helene mentioned the fact that she doesn't have a lot of requests, but she feels that she would have a lot more should people be allowed to have more than one. And by that she means if people know they can apply for more, they will, but they don't apply for more now because they've already used their one, even if their reason is some of the problems that Mr.
Right.
Carver has articulated.
And can I also say that we have had situations where both the owners and the tenants agreed that there should be an extension here, and the rule said you get one, and I can't, right? I can't legally give somebody another extension if they've already gotten one. So I feel more flexibility would be better, but it's your decision, and I will abide by whatever you say.
It seems to me that the meeting ground on this is that we keep the 90 days, but we grant the the executive director more flexibility in how many extensions she can offer. By striking applications for extension of code compliance deadline limited to one extension. Mr. Carver is asking for that to be stricken, so and give the executive director the power to say, you know what, we had a unique circumstance here, I'm going to allow 2 extensions. So it seems to me that's the win-win that everybody.
But if you strike this, you're actually, and not put a number, then you're actually making it unlimited.
Based on the discretion of the executive.
It
just falls down to
There's a
the
discretion to the executive director, so we're just giving her more flexibility and more power.
So this is, I mean, I think Elaine has expressed to the board before that she feels that the need to have a little bit more discretion on granting these extensions. So, I mean, it's our debate. So let's hear.
Well, wait,
Martha
let's-
wants to say something. I'm sorry.
So I wanted to give the board some context, I think, for the rule. Although I was not the author of the rule, I remember the conversations that led to this rule. At the time, it was the legislature's doing that every time they entertained the Loft law, they would extend the code compliance deadlines. So the legislature was giving the owners these extensions in the statute. At the time, the legislature was fond of extending the last 2 deadlines, which is 7B and the C of O deadlines. So we weren't seeing a lot of those extension requests because it was being done by the legislature. That's why the language in the rule talks about amended code compliance schedule, because it was being amended by the legislature. The other thing I wanted to add was that the prior rule, was also correct, I think the board was frustrated by the prior rule. There were 3 types of extension applications, and I don't remember exactly the time frame that the owners could apply for. I believe it was like 1 extension for less than 30 days, then another extension for 30 and 90 days, and then another type of application form that was the extension was like for a year. And the board was seeing many, I don't remember if it was the administrative, if some were done by the staff and some were done by the board, but I remember the board being incredibly frustrated by the abuses and by the frequency of these extension applications, which is why they sort of came up with this limit, and then you could only, and 1 type of application instead of 3. That's my recollection of what was happening, and I believe this happened around 2006.
And they were
Around when?
2006? That's my recollection, but I don't, it has been a long time since I looked at this, so I don't remember.
I would I agree that with your discussion, there was one other factor that should also be taken into account, which is at the time, owners were applying for an extension 2 years after missing the deadline. And the theory was, you want to renew your library book, you've got to come in before the due date to get it renewed, not come in 2 years later and say, I'd like to renew this for 2 years so I don't have to pay the fine that has accrued. So it was it was all over the place, and people were asking for long extensions for a small problem. It was a mess. But now, just to be clear, the current standard is 1 extension for 4 milestones.
It depends on what they ask for. Not everybody asks for extensions for all of the milestones, but if somebody asked for extensions for all of the milestones, we would grant them. And we grant the 1 extension application, and we do it for all of the milestones. The rule actually isn't really worded that way, but if somebody comes in and says, I need an extension for all of them, we will actually send out a letter that says, okay, we're giving you an extension for all of them. Technically, the way the rule's supposed to work is they get the first one, and then they're supposed to come back and ask for the second, and they're supposed to ask for the third. But administratively, we haven't been doing that way, and I did not feel comfortable of setting the out part.
Which contemplates the fact that, different sports leagues have different numbers of time out that a team can take, right? So, in essence, I could ask for one extension for each milestone.
You could, yes, you could come in and say, I need an extension to file my Alt 1, and you could get an extension for that. And then you could come back and say, now I need an extension. Before that one expires, you could come back and say, I need an extension for the permit, and yes, you could do that.
So really, if I'm a savvy coach and I play my team right, play the game with strategy, I currently have 4 extensions, not 1.
Well, you have, yes, but the total amount of time that you would get would never exceed the maximum amount that would be allowed by the statute. So if you came back 4 times to wind up with 36 months to legalize, you would still only get 36 months no matter what. So we're not going to go past the maximum amount of time that's allowed under the law for the legalization process. Does that make sense?
Sorry, Ellen, could you explain what the maximum amount of time is? Because as a new member, I mean, my perception before I was a member is that it's really slow as molasses to get any of these projects to their final C of O. So is there actually a time limit?
Well, if you read the section of law that talks about extensions, which is 284, unfortunately, the last one that the legislature passed is really, really hard to read, but it's roughly a 30 or 36 month period of time to get all of this done, in general.
But we're over that for the 2010.
Yes, we are. That's
So
right.
everyone's
Nobody's in
on it.
compliance. Right. That's basically nobody's in compliance unless they're a new owner or a newly covered building that has applied for an extension and been granted one. So very few owners are in compliance.
I have a chart I just want to read. So I believe you have only 9 months from the claim of coverage to file your Alt 1, get your plans through the buildings, through the Loft Board and the buildings department, is that right?
It's, I'm sorry, wrong book. Hold on. I think when it's
I'm sorry, you have to file the Alt 1 application and the plans with the Loft Board and the building department within 9 months from a claim of coverage. And then you only have 12 months from that same claim of coverage to complete the narrative process, clear all DOB objections, and get a permit issued. So it's that 12 months that's just impossible.
It's 3 months because it's 3 months after the 9 months.
When they're giving you 9 months to follow the information, you're actually going to get 3 extra.
If you took the 9, right, okay.
So the way that it reads now is for an application that's filed after March 11th, 2014, within 9 months of either the date of the initial application for coverage, which could have been way before that, or the date of the Loft Board's issuance of an interim multiple dwelling number, or the date of service of a pleading. That's if somebody goes to court and wants the court to grant them IMD status, whichever is earlier. So for example, to take something like this, we had a new owner. We had a building that applied for an extension, and when we looked in the Loft Board's records, there had been an application for coverage, I don't know if it was in the 80s or in the 90s, which was eventually withdrawn, but that was the date of the initial application for coverage. So 9 months from then would make no sense whatsoever. But that's what the law says, so it's a problem.
Yeah.
Well, I understand it's a problem
Yeah.
to resolve, but I don't think by granting landlords extensions, it's gonna move us faster through to public safety and C of Os, right? It might work the opposite way.
Well, if you look at public safety considerations, and I'm not making a pitch, but if you look at legalization as moving towards public safety, and their landlord has good faith, right, in terms of moving toward legalization, then I don't think granting an extension to achieve that is actually being an obstacle to public safety. I'm just
The unique circumstances, I think, in any of these situations can present themselves where it may require an extra period of time for the Department of Buildings or any of the other regulatory agencies to play a role. I'm concerned that we're limiting the amount of time. If something is in an older building where public safety isn't, it can't be easily addressed without going through multiple reviews. We're limiting our opportunity.
I guess maybe I'm trying to understand the essence of the issue, because if every building is not in compliance, and if Carver's asking,
Many buildings, I should say.
if Carver is asking for an extension that either Elaine, you can grant, or just unlimited extensions, which I don't like the idea of an unlimited.
If you meet the standard, it's not any owner. It's an owner who encounters a reason beyond his control and is operating in good faith.
But what's
always-
the penalty for going beyond extension?
You can't collect rent. I know you don't like hearing it, but
But
you
I
legally
think
can't collect
it's-
rent.
They can also be fined.
I think
Being out of
that
compliance.
withholding rent is a condition that's like based on a desperate situation, and if we actually had a quantifiable number, like I spoke with Arthur Atlas, who has 40 buildings, and he thinks there might be one where there's a rent strike and it's a warranted situation. If we actually looked at the statistics of when someone would not pay rent, you're looking at someone who's in a very desperate situation, and it's a very minor, small percentage of the total amount of buildings.
This is different from people who are lawfully withholding rent for other reasons. I suspect you're mixing the two up.
Okay, maybe I am. If you could explain that.
Okay, so if an owner misses a deadline, he has no legal right to take a tenant to court who's not paying rent for this purpose. So independent, so if a tenant is lawfully withholding rent for other reasons, that tenant can continue to
The
withhold
other reasons
rent.
you're talking about are house maintenance?
Right. That still survives.
No heat, whatever.
That's different from this, where a building out of code compliance who passes the deadline without an extension has no legal recourse if a tenant decides to withhold rent for this reason.
And again, what are the stats on that number? I think it's got to be like 5 cases or less. You're saying 50%. Our two numbers are so different that I don't want to, I just think it's unfair to entertain this without some kind of quantification of.
And that, with all due respect, that plays into my point of how this is going to keep playing out month after month.
Right, I mentioned it 2 weeks
Mr. Carver
ago.
can go out here and he can get his stats, and he can come back, and then some of us, not necessarily you, me, it could even be me, we're going to dispute, how did he come up with these stats?
Right.
And this is just going to keep going back and forth, So either we have to find a common ground, or we have to find a mechanism of obtaining this hard data in advance that will satisfy it. Otherwise, he's going to go out here, and again, an attorney, $150 an hour, you're going to call him up on the phone and say, I need your help with something. I need you to put together some hard data or something like that for a law board meeting. They're not going to be all that eager to set aside billable hours to put somebody on this project to come back in 30 days with information. And then what is the owner's rep? And again, the same would play out if it was on the other way. What is the owner's rep going to do then? Is he going to go back to that same attorney and say, you know what, Steve, I'm sorry, but I'm coming back to you because they're wanting some more information on how you arrived at these numbers. I mean, it's just not realistic.
Does the Loft Law staff have a way to know how many buildings are on rent strike? I feel like it's a very teeny amount. Just like, for example,
You may even be right. I'm just, my whole point, Julie, is that I just don't see how we're ever going to satisfy everybody at this assembly.
oh, I could figure it out. You know what, you talk to a couple architects that are handling the vast majority of the jobs, a couple lawyers from different angles, landlord, tenant side, sit them down, ask them, oh, you have 40 projects, oh, you have 60, how many of your tenants are
That's
paying
what I
rent?
alluded to previously in the meeting. But to have the subject matter experts that you could sit down.
So,
They're not necessarily experts, they're the one, or I guess the way you're calling it expert, it's more like who's handling all the cases. It's a finite amount and there's these bulk groups
Well, an
that are
architect
handling.
that doesn't deal with loft buildings wouldn't do us much good. An architect that does deal with loft buildings would be a subject matter expert.
okay, so this wasn't going to say something, but I just want to jump in and I shift it because we need to kind of move on. But I think it's not so much about stats, but about what what the experts, meaning the staff, know about process and the way things have changed through time and the fact that our rules how far belong, when was this actually? 2006. And has things changed to the point where we need to revisit this to adjust to the process? I don't think stats is going to be able to be interpreted in a million and one ways, and we think we need to hear more from the staff and what they feel on this. I don't, and I'm not in favor of unlimited. I just want to let you know right off the bat. But I mean, we got to be able to come to some mutual ground of understanding and maybe something reasonable, so that we can at least move the process along on both sides. Go ahead.
I was going to say that I think we have to get off the issue of rent and who's paying rent and who's not paying rent, because that's not what this is about. This rule is about allowing somebody who is doing what they are supposed to do to continue to do that and give them the benefits of the loft law. That's what this is about, right? So the only people that are going to benefit from this are owners who the executive director determines are doing what they need to do. There are a lot of owners out there that are not doing what they need to do. I have no
would not
pity on
benefit.
them.
That would not
Right,
benefit.
they would not benefit from this because they are not making good faith efforts. They are not going to be able to prove that it was something outside their control. On the other hand, we have buildings that languished for years, and now there's new owners. They were given extensions. They are moving forward, and they are no longer in compliance with the loft law because we can't give them another extension. Those are the people that are going to benefit. People who are actually actively working to do what needs to be done to legalize. And I think focusing on the rent issue is the wrong place to be. So I ask the board to think about that, okay? Do you want people who are doing what they need to do it in compliance with the law?
I'm just reacting to the way Mr. Carver introduced the topic, which was, he said if we strike this sentence, that then landlords can recuperate rent. And I don't know enough about the legal language. Is that true? This is the one sentence that allows...
If we strike this sentence, right,
Yes.
the one extension sentence, then owners who are doing legalization work and who cannot meet their compliance deadlines for reasons that are beyond their control can get more time. And yes, they will be in compliance with the law, and an ancillary benefit to them because of that will allow them to continue to collect rent. I'm not gonna lie that that's not something that happens, but before before you even get to the rent, you have to get to, is this an owner who's doing what he or she needs to do?
Right, but we already established, I thought, that all the buildings are out of compliance. Is this for some
But they're out of
future?
compliance because they can't, because they can be out of compliance for a lot of different reasons. They can, there are a lot of buildings where the owners have done nothing, and they're not gonna get extensions, even if we change this, right? But there are a percentage of buildings where people are working, and the deadlines have just expired, and they already used their extension.
Again, this is only code compliance, this has nothing to do with housing units.
Can we look at this from another angle?
Sure.
In terms of, and I am the first to acknowledge that not all tenants are perfect. There are some bad actors. Not all owners are perfect. There are some bad actors. I'm sure there's a building out there. There may be a number, I don't know the number, of tenants who say, oh, you know what, I don't have to pay rent because the owner's out of compliance, I'm not going to pay rent. I don't think it's a large number. But let's turn to your example of the people that are doing what they need to do. Right now, the maximum extensions, whether if we said you can have unlimited extensions, you can have 50 per building, you can have 2 per building, there's still a limitation on the time you can give extensions, correct?
Yes.
And
But at
can
least
you-
I can give more, right? I mean, I don't think I could give more than the time that would be allowed in the statute in terms of legalization. But at least I could give somebody time within that time frame. So, you know, like there are owners that came in, new owners that came in, filed for an extension, they got their extension. And also, I'm not so easy, you know, owners will tell you, I'm not so easy when it comes to granting extensions, I really am not. But, you know, they came in, they got their extension, and they had a deadline to get, you know, the permit, and they couldn't get it within the deadline. So now they're out of compliance because they didn't get that permit within that deadline. And so I could give them more time, not longer than the time to achieve 7B, but I could still give them more time. I could extend that permit deadline within that 7B time. You know, like they had a year to get a permit and 2 years to get to 7B, and their year expired, I could give them another 6 months. But they could still be stuck with the 2 years for 7B. Does that make sense?
If you give them 6 months,
Maybe they'll get their permit within the 6 months.
but then does that, at that point, give them 24 months to 7B or 18 months?
18 months from the outset date of the permit, which is set by statute.
Right. So
So no,
to a certain extent,
getting a lot less.
to helping the, in what we can do to help the person that, Helene, you described as doing what they're supposed to be doing what they need to do.
Yeah.
There's still only so many months that we can allocate, regardless of whether it's 1 extension or 5 extensions.
Yes.
Yeah.
Yes.
Is that saying
Yes.
that
Right. So,
there's a limitation to any abuse?
so part of what we're looking at here is an issue where giving multiple extensions is a Band-Aid rather than a real, I don't know why, it's not me. If the timetable mandated by the legislature is unreasonable, this doesn't eliminate that problem.
No, it doesn't totally eliminate it. I would agree with that.
I would suggest, I think I've heard before that there should be a training for how landlords can operate within the milestones, just so they understand as part of
Workshop?
a workshop. I'm all for landlords getting buildings through the system, but rewarding them with extensions when there might be the good players, but there's plenty of other players that aren't really trying to get through the system. So I think or that don't understand it. Case in point,
I guess I'm concerned.
my building.
We keep saying extensions. We're giving the executive director the discretion to grant an extension. Very different from saying, we keep open-ended saying we're giving extensions. We're not. We're empowering an individual who has the authority and the expertise to make a decision as to whether they're going to provide an additional extension based on the circumstances and or hardships that are presented. This is not an open-end extension giveaway. I don't know why we keep saying that. I'm saying I have faith in the ability of the executive.
Well, if we
director
take
to
out
make a
that one
decision.
line though,
Could I add something?
No, it's actually saying, right now, the executive director can only give that one extension if she finds that they are in code compliance, are not, but making good faith efforts, and they didn't meet the code compliance deadline. She can only make that one extension, and by striking this, it would give her the ability to make some,
yeah, I guess I would suggest I'd rather see maybe she can have 2 extensions, limited, not unlimited, and that we address the problem at heart, which is to get landlords to understand the milestones. I don't think it's fair to just say an architect hired doesn't do the work and that needs an extension. I'm an architect.
I didn't say that would be circumstances beyond their control.
I'm an architect, and if you were paid and you could make this deadline, there's not an issue. So I've worked with DOB for years. Like, you can make these deadlines. I understand that there's difficulty in steps along the way, but I don't. If the point of us here is to make the city safer, to get these legalized and through the system, I think we have to be careful on giving unlimited extensions,
Well,
whether it's an executive
I have
director.
language in here that I think addresses this issue.
Yeah, I got it. Okay.
I just want to note that an owner, to get an extension, he has to file that extension prior to the expiration of that. So even if you take this out, that won't help those owners who are already out of compliance for years. This rule, an owner who gets an extension could then file for another extension prior to what was already issued, expired. So this won't help everyone. This will help only a very select few owners who are actually in compliance with either the old statute, the new statute, or something, the extension that Ms. Paulson has issued. So it won't help everyone. This will only help a very small, select few owners.
We're doing the right thing.
And who are doing the right thing. Only, I mean, that's based off of the statutory standard.
And it's only in the future because we're not affecting current cases.
It's procedural, so would it affect current cases if we change it?
If there were pending extension applications at the moment,
It wouldn't?
and we changed the rule, it would not affect them. It goes by the date that application was filed. So it would only be applications for extensions that were filed after the effective date of the rule, which is what
Application
we're also
for
going to do.
extensions.
Right? So if somebody had already filed an extension application, they're stuck with the one. If this rule is changed, then they could get another extension if they filed after the effective date of the rule.
And it's only affecting a very small amount. I mean, I'm wondering why we're talking about this then still. The last rule, there was this, you ruled that we should talk about it later because it only affects a small amount. And now it's seeming like this one only affects.
No, the last rule we can't do anything about because we can't get coverage applications. So, if you're not dealing with coverage applications, it won't affect anybody if we change that rule at this point. If the legislature had acted and opened up a new window period, then it could make a huge difference, but they didn't. So right now, nobody would be affected by that. But here you have people that would be affected by it, and both owners and tenants. And it is a terrible situation to be in, to watch somebody who really wants to do the right thing not be in compliance with the law because we're limited. So,
If there's someone who wants to do the right thing,
well, they continue working. I mean,
and
it's
they're
not
not in
like,
compliance with the law,
right.
there's nothing that's stopping them from doing the right thing.
No, they still continue working. I mean, these people are still continuing working.
Right, so why do you feel bad for them?
No, it's not.
It's not a question
It's
of
not, yeah.
feeling bad, it's a question of them being able to get the benefit of the law.
The law doesn't restrict, our rules restrict.
What are they losing by, they're out of compliance, they're still going forward in good faith, they're working hard,
Assuming they have an
their
income
tenants
stream
are
to
still
use.
paying, right, but the problem is less than 5%, I'm pretty much sure of, if he's saying 50.
But if less than
So-
5%
We don't know that.
don't have an income stream to go forward and address the safety issues and get the building addressed, then it is a safety issue and it is a concern.
With
Whether
those,
it's 1%,
okay, my
50%,
understanding,
or 5%.
I understand that the landlord's hired a lobbyist who's talking about this issue of people not paying rent. The reality
Well, I
is a
didn't say
different
anything about
story.
it. I'm talking about, yeah,
Right, so I feel like we're sympathizing for some guy.
We're not saying-
Every time we say landlord, we say he, by the way. So we're sympathizing for some
Actually, I said he or
guy.
she.
Oh, good, you're the only one.
We should say it, because they're actually LLCs usually.
Okay, so we're sympathizing for some it that I think if we looked at who the its are, they're the ones that are extremely negligent in being landlords.
And now we're back to the data again.
Yeah, and I feel like we're picking battles based on whether it's tenants and landlords, and it has nothing to, I'm looking at empowering the executive director.
Well,
I feel like-
I'm not looking at I like giving a little bit of power to an executive director, but guess what? Our country's in a certain way, and I'm not looking to give executive
Yeah, I'm
power
looking at
to
the federal
anyone.
level.
You have to think about the future
Right.
when a land's not executive director,
I
okay?
think-
So I don't want rules in place that are gonna be
I think
used
you did-
in a bad way later.
Fair enough.
Well, I think then we're at a point where we're just not even, we're just gonna go back and forth, and we're not gonna be able to make a decision here, where I feel like we need to be at a point where we.
I still go back to what, I like what the chairman said. I think we should look at leaving it at 90 days. Empowering the executive director to have the flexibility to grant the extensions as she determines, and strike the line that says applications for extension of code compliance deadlines are limited to one extension. It seems like a common ground that is the only common ground we are even getting close to.
I just want to further know, there is case law out there, so it's not just your total things out of thin air. There is case law out there to help owners make the case for tenants to make the case that the owner doesn't deserve it. So it's not just the owner, it's not that Ms. Balsam is going to just say, oh, this owner deserves it because I like him. It's, no, the owner's doing what they're supposed to by law, and it is supported by the case law that is out there. We're not giving unlimited extensions, it's all based off of the statute and what is already out there.
I mean, the tenants can file an appeal. Like owners file an appeal when Ms. Balsam will deny extension requests. It's all reviewable by the board. Ultimately, it could come before you, and you can agree with her or disagree.
It sounds like though, I mean, what I'm really making this decision on is based on what you just said about 2006. Like, it sounds like there was an abuse of these extensions, and so the board reacted. And I don't want to take it away and introduce more abuse.
Well, the board was reacting to two things. The board was reacting to the multiple classifications of extensions. So I believe that at the time, owners were just filing like 60 or 90-day extension requests repeatedly, which I believe at the time could be done ex parte.
Could be done what?
Ex parte, without the tenant's input. So it was either up to 30 days or up to 60 or 90 days. I mean, it's been a long time since I reviewed this. So I think that was one of the things that the board was reacting to. Another thing that the board was reacting to was the legislature's constant extension of the code compliance deadlines. So the board didn't see fit to extend more than once if the legislature wasn't extending it, which is what they were doing routinely. But that is no longer the case. The legislature is no longer, as a matter of course, just extending these code compliance deadlines. They've stayed constant. The only time that they're extending it, in fact, recently, they shortened it by 6 months. I believe that was in 2015, 2015, I don't remember which amendment it was. So that's no longer what's happening. That was the landscape at the time. That's not what's happening anymore. I think the legislature finally heard the board in telling.
Who is the legislature? If there's, building codes are always being updated.
Mhm.
And so I could see someone wanting an extension if energy codes, they have to modify things to be compliant with a new code coming in. And there are new codes coming up. So when you're saying the legislature doesn't rule that way, who?
The legislature at the time, so what they would do is when the law came up for renewal, they would extend the deadlines in 284 to some arbitrary date. Now that it's sort of tied to something, but at the time it was some date in the future. And at the time I remember it being the last two deadlines, the 7B and the CFO deadline. They were routinely just extending those two deadlines. My understanding at the time was that the board took the position, these are the two most important deadlines. These are the two deadlines that deal with safety. So the board constantly was, and the staff were constantly telling anyone who would listen that the legislature had to stop doing that because they were directly impacting the safety of the people who lived in IMDs. So the board, in doing its rulemaking, put that in its rule that it was limited to one per amended code compliance schedule.
To give some background to all the members, I think, I actually spent some time on this, going through the various timetables that are set out in 284.1, little I, little double I, little triple I. They froze the alt-app and permit requirements for the first time in 1999. Prior to that, for the first 17 years, everything got shifted, which meant, at that point, the owner who'd done nothing was given a "you're completely in compliance" ticket by the legislature each time the loft law was renewed. In 1999, they froze the alt-app and the permit for the alt-app September 1st, 1999. That's still on the books. And the permit March 1st, 2000. They then moved the 7B and CO requirements so far that the last time, the ones that are on the books now for the original buildings, not the expansion buildings, the original buildings, is June 1st of 2012 and July 2nd of 2012. So they moved those two for a period of 12 years. And this led to over multiple renewals. The loft law was renewed many times during that period. That led to the tenant criticism that all the landlord has to do is get a permit and then they can just sit. So, and it was against that backdrop that the extension situation got looked at. I want to say it was earlier than 06, but, and you've been here quite a while now, Ms. Cruz, so it could be.
This particular version of the rule that we have now was definitely passed in 06, that I can tell you.
Okay.
They may have been permutations earlier than that, but
Yeah.
we've had litigation around it, and I had to actually do that research.
Okay, so we've had quite a bit of time for people, unless somebody really urgently needs to say something, can I make a suggestion as to, Mr. Carver, I don't agree with, I told you that, unlimited extensions, but can we, or would the board be amenable to making an application for extensions of code compliance deadline would be limited to 3 extensions for a deadline in the amended code compliance That's something that we could work with,
Actually,
Would be limited to what?
to 3 extensions
Per deadline?
per deadline.
Ronaldo, I think
This is up for debate.
it's better that you look on page 3 where the language that I have first out, which I said is the heart of the matter.
Page 3.
Page 3.
Yeah, that's where I am.
Right. Right on top of it, the new underlined language that I'm proposing is giving the staff the ability to set the time frame of the extension to reach the next milestone.
Can you do that by code?
To reach the next milestone. That means you don't need to worry about number of times. This way, you guys are setting it up so that the owner can meet it. And in the event another of these obstacles comes up, then the owner would have to ask again. I don't know that an arbitrary number is meaningful in this context when...
Wouldn't the owner then have to kind of manage their own property? I mean, right? I mean, my point is, why should we think about it for you, for the owner, that is? But wouldn't you, once you got the extension, be able to manage and kind of do your own managing to make sure that you can meet that?
Well, the owner will be asking for a specific time, but you with the staff would have the authority to make it, to accept that, make it longer or make it shorter, all depending on what the staff thinks is warranted.
Meaning the staff.
Your staff.
Elaine would have that discretion. The executive director, I should say, the executive director.
Why would the executive director extend what the request that the owner is asking for to a longer period? Why? That means the executive director would be doing the owner's work for them, trying to manage their own.
All right. If you don't want flexibility, I guess that's okay.
No, it's not. Okay, so an owner comes in and says, I need 2 months. Why would the executive director come in and interrupt that and say, well, I'll give you 3 months instead, because I think the 2 months you're asking for is too little.
I'll give you 3 months so that you don't have to come back, because I think I happen to know the building department is.
But if you come back and you're not acting in good faith, you know what I mean? What do you think about it, Elaine?
Yeah, to the extent that the delay in granting the application could have been caused by staff, we would want the flexibility to be able to give them, if they asked for a year and it took staff a year to get to it, and I can say it hasn't taken me a year. Sometimes it can be a few months. You might want the flexibility to say greater.
But why can't we carve that piece out in the rule then?
Well, you could have the extension run from the time that it's granted. That would be.
Okay, so we have to work on that, but I'm not in favor of the executive being able to just give you more time than you asked.
But what if circumstances have changed while the application is pending?
Like, for example, September 11th. That's, of course, Hurricane Sandy or something
So
like
then
that.
let's carve out some language here.
Oh, wait a minute. If that were the case, if there is more than one extension application allowed, then one approach would be filing another. Because I've been reading for a while now of the language you proposed about the executive director will grant an extension period that is reasonably necessary under the totality of the circumstances for the owner, which sounds like the executive director has to be a mind reader.
Well, the owner would have to make the case. I guess the owner would have to say, here's why I need X amount of time. And obviously, since the tenants would be on notice, which they didn't used to be under the old rule, the tenants would have a right to come back and say, oh, it's ridiculous, the owner shouldn't need that amount of time.
Well, I have to tell you also, these words are very known to lawyers. They're not, these phrases, reasonably necessary, the circumstances, these phrases are well known to lawyers, and it's not unreasonable to use them in the definition of the standard.
I understand, even not being a lawyer, what reasonably necessary means. Totality, though, is one I haven't counted that off. Totality of circumstances.
That's pretty typical, yeah.
All right. No.
To say, well, we already have it.
So can we just, if we don't agree with that piece that you've, and I'm just talking, if we don't agree with this addition, the underlying piece here, just did it three extensions per code compliance deadline, is that something that the board?
Two. How about that? I like more than one, but I don't, 3 starts to get ridiculous, right? Potentially.
I can tell you, did anyone see that? Did anyone read the latest draft of what was before the legislature? That last bill, final draft of the bill.
I guess so.
Okay. All right. It's on the lawyer, but it was the latest draft before the legislature included language that's of unlimited extensions, and that was apparently some kind of agreement or deal between owners and tenants with that language in. I'm not saying I liked it, but if it was law, then that would have been law. But I'm just going to get your point about 3 versus 2. I still think that's way better than unlimited, but I don't think.
Yeah, I mean, I guess I agree with you that I like giving the executive director more power, but I like it capped with a certain amount.
I prefer it to be 2.
Because otherwise it's too limitless, and
Well, if this would move things along, I think that's going a lot more. Mr. Carver, what do you think? I mean, I think this is a lot more than just having one extension per code.
Of course, I mean, anything more than one is better, but in all honesty, plucking numbers out of the air, that's really arbitrary when I've established a standard. And again, because life happens, you hit obstacles that you don't foresee, and it could be more than one, it could be more than 2, it may be more than 3. And the fact that the tenant advocates in Albany pushing the bill have no problem with the lack of limit, the limit speaks volumes on this issue, frankly.
I'm not speaking for
I know.
for what brought this along and what negotiations, but I'm going to put 3 on it for a vote. I can't make a motion. Someone
3 on the table.
would like someone to make that.
do we have to vote
Then we
on
see
these?
where it goes from there. Right.
Well,
We
really,
have to
if
vote
we're going to change the rule, if you want us to draft a rule.
I would like an extension to study this more.
It's not a final vote, it's just to keep it moving. It's
Yeah. This is not final language.
Right.
By any extent.
So this whole thing, this exercise is basically moving things along, and then the final rule will, not final, but the final draft will come again up. Always.
We can't, according, pursuant to the Loft Board rules and legal in general, we can't publish proposed rules in the city record until the board signs off on the language. So this is just, are we going to deal with this, and how are we going to deal with it? So we would add this section as a section to the proposed rule if the board agrees to. So that's what you're voting on. Does that make sense?
I would be willing to support making it for discussion purposes later on 2, and when we get to public hearings, let owners come in and make their case why 2 is not enough.
if I don't have another motion on the table, then someone should make a motion.
I'll make that motion.
Well, I think you had that motion already for 3. I mean,
But I didn't.
No, he can't make a motion.
I was just trying to move things along.
let me ask you this, so how many do we need to, I mean, in terms of the
5.
county votes?
5,
We need 5, not 4?
5, because you need a majority, now 8, so a majority of 8 is 5.
Okay, and how? We have how many sitting here today?
But it doesn't matter, it's the majority of the board as a whole.
No, I'm just trying to.
Oh, I see.
To count votes now.
Probably going to run into here with
There's
this.
6.
Hang on a second. The problem you're going to run into here with this is, you know you have people here that support 3 or support the executive director doing, but yet you have a vote, the first vote is likely the one that may pass. So
But
if
again-
the people that want the 2, if that's the first
There can be two motions.
Can I just clarify? The motion should be to add this to the proposed rule with a limit of 2. That's what the motion should be.
Right, but what I'm saying, if that passes,
Right.
then the 3 is now explored. So the people that support 3 don't even have a chance to vote.
Well, let's just go around the room without voting to see where people stand.
Okay.
We can do
We
straw
can
poll,
do
that's
straw poll. Okay.
I should tell you, if I have to be forced into a number, I would obviously support 3 over 2.
Okay. So, by show of hands, I suppose it's a straw poll, not an actual vote. So, how many would support having a limit of 3, let's start with that, of 3 extensions? And that would go for 2. So that would be 4 out of 6. But that doesn't count,
Right?
because you need 5. Okay, so,
Well, we can wait for more members next time.
Which would actually give Julie what she was asking, which was a little more time to ponder this.
Well, let's talk about that concept. Last meeting, I had something on the floor and we decided not to vote on it because 2 members were missing. 2 members are missing now. Mr. Schachter, I'm looking at my notes, has missed 3 of the last 4 meetings. If we start saying, let's not vote till everybody's here, we're going to need extensions.
Fair enough.
So I'm perfectly reasonable. And even if we said 17 per milestone, our hands are still tied as to how much time we can give.
can I say this, Mr. Delaney, the motion did not pass. Do you have a motion?
Yes.
On the table?
Well, it wasn't really a motion.
Oh, it's a straw
Well,
poll.
it's a straw poll.
My,
The straw poll, you want to go to an official vote then? And that motion?
No, I just, if it was,
No,
I
I
just
think
want to clarify.
procedurally though, do I have to have an official vote that knocks that motion down right now? And then go to another motion? Or do I just have another
you
motion?
didn't have a
You
motion.
didn't have a motion.
No, not me.
But you really need a motion just to get a consensus.
Oh, there was no
Wait,
motion, that's right. There
We're
was no
just trying to
motion.
get consensus.
Maybe we should just take a voice to whether or not we should even add it to it. Just don't worry about what it's going to say. We should avoid it.
I feel differently. I think there is merit to the argument that owners might need more than one exemption. I don't accept any of this language that is in here about the totality of the circumstances and everything else, but I would be supportive of changing the language that was stricken in this proposal, the third and second to the bottom lines, applications for extension of code compliance deadlines will be limited to 1 extension per deadline in the amended code compliance deadline. 2 will be limited to 2 extensions per deadline in the amended code compliance deadline. And I'm making that a motion.
Okay. I think Helena's point was, we accept.
Well, that's his motion. His motion is to keep the rule as is except change 1 to 2, am I correct?
Correct.
We have a motion on the table. Is there a second?
Wait, can I ask a
I'm sorry.
question? So the 2-1 versus 2, what about the executive? We're not
No,
talking about
that would be striking, that would not be added.
The executive director is going to decide no matter what, because that's who has the power to decide in this situation, who decides extension applications. And the board decided that years and years ago, that it would be an executive director determination. So the executive director will still have the authority to make the determination, but it's whether or not the executive director could make 1 or 2. Mr. Delaney's motion.
So I would just change, in these 2 lines that are crossed out, I would change 1 extension to 2 extensions.
And what about all the other stuff that Carver sent? Are we not talking about any of that?
I'm not.
I think Mr. Delaney's motion is to reject everything there and just to add back the line, applications for extensions of code compliance deadlines will be limited to 2 extensions per deadline.
We didn't talk about any of the other stuff.
Right,
I mean, that's, and with due respect to Mr. Carver, who pointed out that there are other things that are maybe cleanup language, I'm happy to go over them after we act on my motion,
Okay.
if I get a second.
Is there a second to Mr. Delaney's motion? And that is limiting the changes to only 1 extension, from 1 extension to 2 extensions for code compliance deadlines, and not anything else as drafted by Mr. Carver. And you're saying we would revisit the other issues?
When Mr. Carver started his presentation, he jumped to page 3 and said most of the rest is just cleanup language, but I'd certainly be interested in discussing that. I'm not saying strike. My motion is not to do away with everything here.
You mean you only accept this for now?
Yeah.
Okay, I got you. So is there a second to Mr. Delaney's motion? Okay, so we don't even have a second.
I mean,
Can't help
I
it.
just feel like we're rushing into this if we haven't even reviewed the rest of the language, and
Well,
then we're
we're-
gonna vote and no.
It's not, I mean, it's not like it couldn't be brought back up.
Can I just say that without a vote to even consider this and make it part of the
Right.
proposed rule, there's no reason to discuss anything else. Right, why talk about the rest of it if the board is not willing to even entertain this and make it part of the proposed rule? Right, so that's really what you're looking at. Do you want to continue to talk about this and we're going to put it into the proposed rule and move forward? For now, if that passes with limited to 2 extensions per deadline, and then you could still go back and talk about the other proposed changes.
I would like to withdraw my motion. And instead, I would suggest that one of the other things that would be useful, which I hope would not be too much work, would be if the staff could give, a few years ago, when I was looking for this, before I found it, there was a summary some years ago of extensions in the past year. I'd be interested, I think it would be helpful for us to know, and it doesn't have to be exact, but in the past year or 2 years, did 4 extension requests or 40 extension requests or 400 extension requests come in? And of those, how many were granted? So we have some idea of, in general, how the extension request system is functioning as it currently exists.
Fortunately, it's the perfect time of year for that, because we have interns to do. And I would suggest that we go back to September of 2016, because that's when I started.
I second that suggestion.
Okay, so there's no motion on the table. we'll pick up with rulemaking, and I guess we can probably go back to this next month's meeting.
Yeah, certainly I would like to talk about the other changes. I focused on the substance in the interest of time, obviously.
Right, okay, I got you. So, so there's no more, with no more motion to table, I would like to bring this meeting to a conclusion if there is.
Mr. Chairman, I have one request. In the private meeting, I raised the question of how going forward, members with suggested language could or should submit it to the board. And, you know, when I suggested some language changes, I sent it in a couple weeks before the meeting. When the mayor suggested language changes, they came an hour before the meeting. I'd like to see if we could come up with some protocol.
I can tell the mayor.
Yeah. And my feelings aren't hurt, by the way. And Mr. Carver's language was on the table for a week, which seemed eminently fair. We have a portion in Chapter 1 of the rules that allows the public to petition the board for rulemaking. So I would be appreciative if we could try to, and I have a feeling that this is, in terms of it's the perfect time, I have a feeling that we're going to see more suggestions coming in from either board members or from the public. So I would like us to have kind of a protocol in place.
And that, are you suggesting that we, that the executive director draft up a set of protocols for submitting stuff to the board to be considered? Is that okay?
My suggestion in the private meeting was that we discuss it today, but it was yeah, I don't know.
So could I get, if I could get input from the board members as to how long lead time you think you need, and obviously that's going to depend on the length of the document and how complicated it is, but just a general sense of what amount of time you would need.
And how you're going to get that, you know, well, she'll decide that, but in protocol, but I guess if you could just do that within the next week, so we should have some time to put the document together, and we bring that to the board for discussion next month. Is that all right?
Sure.
Thank you. All right, this will conclude our June 21st, 2018 Loft Board meeting. Our next public meeting will be held at 22 Reed Street, first floor, on July 19th, 2018 at 9:30.
9:30? No, 2. 2 o'clock. That's just the list.
Can I withdraw that?
2 o'clock.
2 p.m. Board members, please sign, please turn in your attendance sheets. Thank you very much.